This has a connection with the division bench matter where Lordship has just adjourned the matter. So
there's a pay commission.
So may I pray, matter may come up after 3 weeks, since DPA has adjourned the matter at 3 weeks.
We'll give it 4 weeks then.
Oh, yes. Okay.
On pray made by the petitioner, submitting through Mr. H.L. Sangrisul London Senior Counsel, who has stated that similar issue as could be found in this petition is also the subject matter of a case before the division bench of this court, and as such accommodation is sought for in this matter. As prayed for, list this matter after 4 weeks.
My Lord, I beg to mention item number 19, my Lord. On behalf of state respondents, Mr. Sen Gupta, my Lord, he is the counsel appearing for the state. 19, my Lord.
19 is not a state.
My Lord, Mr.
Are you for the is the state involved here?
My Lord, I have been informed by Mr. Sen Gupta that he is appearing in this matter and he is not keeping well. I do not know.
He may have appeared, but I don't think the state is this Deepak Mittal.
My Lord, yes. My Lord, if state is not
You are
party,
for?
I have come here before, my Lord, on behalf of Mr. Sen Gupta.
For respondent or petitioner?
He has just informed me that he is appearing for the state respondents. I do not know whether the state is a party or not. If not, my Lord, I tender my
I
apology.
think who's Mr. Paul?
Mr. Senior Counsel is there on record. Yeah, state is a party here. My Lord, state is a party, my friend has informed.
Okay. Who's for the petitioner?
Sir, Nitesh Mursika. Deepak Mittal. Yes, Mr. Sen Gupta is not well, my Lord, so...
No, state is not...
My Lord, in that case, my Lord, I tender my apology because I was just informed by Sen Gupta he is not keeping well. I tender my apology.
argued in this, he's not
That's what I was wondering because I recall
My Lord
this.
has also informed. Because his name is reflected, so he just texted me that if
Oh, yes, his name is there.
reflected, my Lord.
Name is respond number 2.
Any objection?
No, my Lord, I cannot make any submission if state is not a party.
In fact, your Lordship has heard the matter and we've placed the citations, and then my learned friend here has requested for time to place some citations on first occasion, on second occasion, and on third occasion. I have filed my written argument also, but all the citations. Now he's here again.
This is that
Those grinding balls media.
grinding balls. Yeah.
Lordship will pray for 1 more week, Lordship, to file my written argument, Your Lordship.
On primary respondent, this is matter to 1 week.
Highly obliged,
Right.
Lordship.
Lordship, a CRP was filed. It had gone to Justice Thank You's court, but His Lordship has accused himself because of one of the advocates appearing for a party there. So I believe the matter would be delisted in your Lordship's court.
It'll come in due course. It'll come.
Lordship, I have a humble prayer for it. I was about to make the submission there, but since Lordship over there is recusing, he has suggested me rather if I could make a submission here and mention, Lordship, I would be out of the country for this coming week. So if that matter can be taken up on the 7th of July.
7th of
July.
You can do one thing. Let the matter come. Perhaps it may be listed on Monday.
Lordship.
You request any of your colleague to make a mention on your behalf, and the matter will be adjourned.
7th of July. CRP.
Whatever. You just request your colleague to rather instruct your colleague, and then let a prayer be made, and I'll pass these orders. Excuse me.
May I please, Your Lordship?
Yes,
Your Lordship, I beg to mention item number 18, Your Lordship. Let this matter be taken after 2 weeks.
You're for?
I'm for the petitioner. I already take the consent from Mr. K.P. Patajaji, Your Lordship.
On prayer made by the petitioner, list this matter after 3 weeks.
Your Lordship.
Please, Your Lordship, I beg to mention item 11, due to the personal difficulties of the senior conducting counsel. So, Your Lordship, we pray let this matter come on Monday.
First, you seek, indulgence from the court. Then you put a condition. So that means the court has to comply with that you have to take certain cases on a certain dates according to your convenience. So what do we do, miss? If you're not feeling well that day, then the court will say, okay. But it's 2016 matter.
Yes, Your Lordship.
On prayer made by the, who's for the respondent?
Sir,
State?
Sir. 11, Kumar.
But I am for the state, but the main respondent is my lord, the
I already seek
MTDC.
their consent, Your Lordship.
MTDC?
Respondent number
Oh,
2 is the
that.
main
Sir, send.
This is a termination matter or
No, no, this is the case where, to my understanding,
After-
after,
after
DP was
such-
initiated after return.
yes. I now I recall weekly. Prayer made by the party, by the petitioner. List this matter after 2 weeks.
Much obliged, Your Lordship.
My lord, I beg to mention item number 9, a week time block. I've informed the other side.
On prayer made by the appellant, list this matter after 2 weeks.
Deploy.
My lord, I beg to make a mention of item 16, my lord, of the hearing text. I had informed, my lord, the petitioner
Mr.
counsel.
Nongklao,
Yes, my lord. I had already informed him.
on prayer made by the respondent, list this matter after 2 weeks.
Obliged.
May it please, Your Lordship. Lordship, I beg to make a mention on item number 14, Your Lordship.
14.
I'm for the private respondent number 4, Your Lordship.
What is this matter about?
This is about taking appointment.
Yes, it's regarding appointment, Your Lordship.
School.
Yes.
On prayer made by the petitioner, list this matter after 2 weeks.
Your badge, Your Lordship.
Yes, Your Lordship. Lordship, with your permission, I want to mention one matter for certain clarification, Your Lordship. Lordship, I'm appearing on behalf of Mr. T.T. Dingdo, Senior Counsel.
Yes.
Lordship, this matter concerns the order whereby the commercial court has come to a conclusion that under section 82.
Yes, I remember, I recall.
Lordship, this in fact, on that day, on the 21st, 6th, when the hearing was taken up, now Lordship had agreed that the date will be fixed after 1 week.
Yes.
Now, on perusal of the orders, Lordship, it's reflected after 2 weeks. Some urgency is there because it might become infructuous by this time, Lordship. A week's time was given to the respondent. So now it's reflected 2 weeks, Lordship. Now the matter will appear on 6/7. On the next page, Lordship, there's a CIS status, whereby the date is reflected as 6/7. The next date is 6/7, Lordship.
Yes. What do we do?
We will have to view that since the matter will come up after 1 week, so we
Yes,
will
yes.
agree to that 1 week time. Now we are in this confusion now. So I have informed the Mr. Jindal as well, Lordship, that will be mentioning the matter.
Where's Mr. Jindal?
We have informed him yesterday, but I don't see him today.
What do we do in such a case? Do you need to file an application or just mention it at the bar? I don't know.
I don't know what is the procedure, Lordship, but I just want to point out before this.
Maybe. See, through inadvertence, it could have been.
Yes, Your Lordship.
That
Lordship.
if the parties have said so, then
Lordship.
it must have been. But how to? You cannot just see off the cuff. It cannot be done.
Because the orders are already passed, and Your Lordship has already.
So you do one thing. Try to contact Mr. Jindal. Try to find out the proper course.
Lordship.
And then,
or maybe we can file a small application.
Whatever. So but let it come on Monday.
Or for Monday or Tuesday.
Monday or Tuesday.
Lordship.
Fine.
Very good.
From supplementary cost list, item number 1.
My lord, I'll seek a small indulgence, my lord. I was the one, in fact, who insisted the matter be fixed today. But my lord, I have a terrible flu suddenly. I'll not be able to argue today, my lord. I'll just pray if the matter can be taken up on Monday.
You have a flu, but I don't see you sprouting wings.
Very bad one, in fact, my lord. I thought I would be able to argue. I'm prepared otherwise. Just till Monday, my lord, because the trial court also the matter is fixed on Monday. That is my anxiety. Otherwise, I would have asked for 2 weeks' time, my lord.
As prayed for by the petitioner, list this matter on Monday.
Much obliged. Thank you, sir.
DD cost list, item number 1.
Taken steps for respondent number 2. The AD card has not yet been received, returned. But the track consignment, it is showing that the item has been delivered on 13/6/2023.
It has been delivered?
It has been delivered.
Then have
so
you
I have
filed-
to obtain the delivery certificate.
Okay. We do that.
And I will file an affidavit if required. Your Honor.
As far as the rejoinder is concerned?
Rejoinder also, I need time, Your Lordship, 3 weeks' time further.
You're appearing for all the respondents?
Lordship for 9 to 12, 9 to 11.
For 1, 2, and 4.
Except for 2.
Except for 2. They are appearing for the others.
Mr. S.D. Upadhyay, learned counsel for the petitioner, has submitted that the notice issued upon the respondent number 2 appears to have been received, inasmuch as a perusal from the portal of the concerned post office would show that the said consignment notice has been delivered. However, it is submitted that an affidavit of service may be allowed to be filed in this regard. Reallowed. As for the rejoinder affidavit to the counter affidavit filed by the other respondents, in this case, the learned counsel has sought for some more time in this regard. Sought for some more time to file the said rejoinder. On premier, the same is allowed. This is matter up to
3 weeks, Lordship.
3 weeks.
Item number 2.
In this also, Lordship, I need further 3 weeks' time to file rejoinder to the affidavit of respondent 1 to 8. As for the 9, 10, and 11, till date, no affidavit has been filed.
Yes, Mr.
Lordship, we need some more time to receive instruction from the department.
Mr. S.D. Upadhyay, learned counsel for the petitioner, has submitted that some more time may be allowed for the rejoinder to the counter affidavit filed by the respondent 1 to 8 respectively may be allowed. As far as respondent 9 to 10 are concerned, the learned counsel appearing for the respondent has submitted that some more time may be allowed for the counter affidavit to be filed, since no specific instructions have been received in this regard. On premier, this is matter after 3 weeks.
Item number 3.
This is that matter, my lord, where we are seeking quashing of a proceeding pending before the learned GMFC Joy, my lord. Here, my lord, we were directed to take steps against respondent number 3, which we have already taken, my lord. And I'm informed, my lord, the delivery is confirmed.
Have you filed
I haven't filed, my lord. I am seeking your lordship's permission to file an affidavit to that effect.
Mr. S. Thapal, counsel for the petitioner, has submitted that the notice issued upon the respondent 3 has been received by the said noticee. However, the affidavit of service in this regard could not be filed today, and as such, some time is sought for the same to be filed. As prayed for, this is matter after 1 week.
Lordship, next week I'll be out of station, Lordship. If it is after 10 days or 2 weeks, Lordship.
Are you required to produce the...
No, not required.
But you can do so. At least what is the status of the case? Or this matter has travelled...
It's proceeding, my lord.
CC completed, Lordship.
CC is already completed, my lord. The court has declined to discharge him.
That is why.
Okay. So now charges will be framed.
Charges will be framed, my lord. That gives me all the more reason to, my lord, seek some kind of a stay, my lord.
Then let the copy of the CD be produced.
Let the record, my lord, if that be the case, because on the earlier occasion, my lord, we had...
may not be necessary. See, because in the CD, copy of the charge sheet also will be there, yes. I presume.
May not be, my lord. In the charge sheet, copy of the CD will be there, but in the CD, my lord.
Yes. So you understand? Bring all the relevant report under 173, which would include the CD and other things.
In fact, I have annexed already, my lord.
You have annexed?
Yes.
What you have annexed? What?
I have annexed the copy of the 173, my lord. Yes.
And also the
FIR and the order passed by the
statement under 161, 164.
Those have not been, except for few witnesses, my lord. We have not annexed the entire 161. That is why, my lord, I was praying if the records could be called from the...
Records cannot be called for because the case is ongoing. What we can do, more often than not, we used to request the prosecution to file a copy of the... So, Mr. Sheikh, do that.
We'll collect the photocopy of the 173, records of the 173.
Fine, 1 week.
2 weeks.
2 weeks.
2 weeks.
All right.
Item number 4.
May I please your lordship? Lordship, I am entering a parent on behalf of respondent number 5.
Number?
5. And the other items from up to 8 is analogous matter. Similarly, I am entering for this thing, and I pray for 4 weeks' time to file my counter. My affidavit.
What about the state?
Lordship.
Have you filed your counter?
No, Lordship. We have received instructions, Lordship. We'll be filing our affidavit.
For?
On behalf of the state.
State. Okay, state means state.
Exactly,
whoever.
analogous, Lordship.
Yeah.
Yes.
Mr. Lordship, for item number 5, we are entering appearance for performer respondent number 6, Lordship.
Oh, who's 6?
He's the Sardar.
6 is a Sardar, Your Lordship.
You are appearing for all in all cases?
No, only for item number 5, Your Lordship.
What about the other?
I've taken the due steps, Your Lordship. Irikara yet to return.
He is the same person?
He's the same person, Your Lordship. And all the 5 villages, same Sardar.
Then why are you appearing only in one case?
Your Lordship, because we have been instructed only for this particular. We have received notice only for this particular case, Your Lordship.
Okay. What you can do is this: if you have received notice only of a particular case, you can request your friend to hand over to you the petition in the other cases, so that you can also appear.
I can do that.
If the one and the same person, it looks odd when you're appearing in one and not appearing in the others.
Lordship, if I may, there is a prayer, Lordship, interim prayer, Lordship, pending disposal of these petitions of your Lordship, can kindly consider directing the state respondents to release the funds, Lordship.
Let that be examined first, Lordship.
That will have to be examined.
Yes.
Because the funds have already been allotted, your Lordship.
Whatever the case, you see, the funds will remain as they are.
Correct, Lordship.
As and when the time comes, when you are entitled to it, or whoever is entitled to it,
Lordship.
they will get it.
Correct, but those funds, if they are not being utilized, they'll revert back, they'll be returned. Because these funds are related to development of roads, your Lordship, roads and proper water, sanitation, proper water storage, your Lordship.
Nevertheless, Lordship, there's an application pending. Let us reply to it, Lordship. Let us reply to it before such a prayer can even be educated.
Miss, you have to also understand. We don't know. See, I personally, I don't know how government function or how administration function.
Lordship.
If the funds meant for such project,
Lordship.
If not utilized in within a specific time, and the labs or they are diverted to some other areas or fund, that is a concern.
Lordship, that's concerning, Lordship, but nevertheless, Lordship, we have to reply first. We have to examine the documents, because what if, Lordship, it's otherwise? Then it should not be towards the petitioners over here standing before.
No, we are not talking. See, we are not talking about the petitioner or anybody for that matter.
Lordship.
We're talking about the development fund meant for a specific area.
Yes, Lordship, it should be released. I agree totally. But then,
I am also not saying that it should be released. What the court is concerned is, if per se that fund is not utilized, it might lapse,
Lordship,
or it might be diverted to some other projects or area.
Lordship.
So
we'll make an effort to file
what
our
you can do,
affidavit at the
what you
earliest,
can do,
Lordship.
Ms. Silla, perhaps a direct order may not be passed in that regard.
Lordship. Yes, Your Lordship.
You can caution your officers.
Lordship, we can do that, Lordship.
Put it on hold.
Lordship.
I think you
This
have
is with regard to petition 135 and 136, Your Lordship.
whatever. You
We'll
can
examine
inquire from your colleague, and then
Lordship, because
Yes.
we have received instructions, Lordship, accordingly.
you see that is also proper, because
Lordship.
even if a specific order is not passed,
Lordship.
because the application of the petitioner in this regard has to be heard when all the attending respondents are present.
Understood, Lordship.
Appearance has been made. Have you filed your power, Ms. Sangeja?
I'll be filing.
You'll be filing.
Yeah,
We
for all
already filed today, Your Lordship.
Mr. S. Sangeja, Learned Counsel, has entered appearance on behalf of the respondent 5 and has submitted that he may be allowed to file the power in course of the day. Course of the day, or within 1 week, or
No, course of the day. Now it's
course of the day. You are for 6 or 5?
for five, for all the
You are
cases.
for 6.
Yes.
For all the cases.
Ms. has also submitted that she is entering appearance on behalf of the respondent 5. 6. You are 6.
On 6, Your Lordship.
Sorry, for 6. As far as the state respondent are concerned, Ms. N. G. Shilla, Senior GA, has submitted that the counter affidavit may not be, could not be filed today, and has sought for some time same to be filed. On the interim prayer made by the petitioner, matter will be heard when all the respondents have made their formal appearance before this court.
My lord, if I may make a submission, lordship, since the petitioner has brought forth before this honourable court about release of certain funds, lordship, it would be much more proper for me to seek instructions if they file by way of an application, lordship.
That has already been done.
No, lordship, there's no miscase. There's only a main case, lordship. There's no miscase, lordship.
No miscase, lordship. I've annexed the
But have you made a interim prayer in your?
Yes, Your Lordship, in the main case.
But there's no formal listing.
There's no formal application, Lordship.
Yes,
And in this Honorable Court is a practice, Lordship. That is a separate miss case to be filed.
Yes, for interim prayer or stay, you more often than not.
Lordship.
You like I said, unofficially you seek.
I can do that, Lordship, but then it would look strange if I press upon the state for such a matter if there's no application present, Lordship.
Apparently, see, it is there in the petition. It's not necessary that it has to be if there are specific rules to it. But if you point out the rule, High Court rules to that effect, perhaps. If not, once it is in the petition, the court can take cognizance of that. So how long?
Lordship, 3 weeks time.
This is matter of the 3 weeks.
That is my Lordship.
My lord, make it 4 weeks because my client is residing in the rural areas from this Langja or Langpi area. So 4 weeks time.
I understand. So it'll take her 4 weeks to come here by Punekat.
No, I have to take instruction. But,
since Langja is very far from Shillong, so perhaps.
That is the main prayer in this writ petition, to release the fund.
That will look into it. This is matter of the 4 weeks.
Much obliged, Lordship.
Item number 5.
Same. So 5, 6, 7, 8.
Item number 10.
This matter we had taken steps as against the respondent number 7.
Who's respondent? No, respondent number 7?
Parents till date, Your Lordship.
We have filed the affidavit to the effect, my lord. It was filed on 7th of June.
Who's respondent 7? Oh, Darwash, no.
Yes.
No, you have not taken steps earlier.
We had taken, my lord. In fact, the respondent number 7 was already represented by Madam Sheila.
Oh, okay. So you are supposed to. Okay.
Yes, she retreated on the ground that she is now on the panel. There will be a conflict of interest.
But where's Madam Sheila? She's not here.
Lordship, I think she went to the court number 2.
She had expressed that she won't be appearing.
No, that is true. But but courtesy demands that she inform her client that she's no longer appearing, so that they will be able to make alternative arrangement.
Otherwise, we have already filed the affidavit, bring on record the steps and the delivery confirmation by way of an affidavit. We can wait for another date, let them appear in case they make some arrangements to have them represented by somebody.
Fine. Mr. Estapa, Learned Counsel for the petitioner has submitted that fresh notice has been issued upon the respondent number 7, and to this effect, an affidavit of service has also been filed for this court. However, the respondent number 7 is yet to appear before the court. On prayer meet, the matter is adjourned for the day to allow the respondent 7 to appear before this court on the next date fixed. This is matter after 2 weeks.
Item number 13.
Yes, Mr. Sai.
Lordship, I appear on behalf of the state respondents. In fact, the order inadvertently recorded that we were to file our written submissions. We had already filed our written submission, and the matter had already been
Matter has been argued.
I have given my authority also.
Okay.
Matter has already been argued.
And you filed your written argument?
Yes, I have filed.
Submission has been
This is
made.
a case of medical negligence, Lordship. The allegation.
Fine. Anyway, we'll look into the matter. See, parties have submitted the written argument. By both sides have been filed in this regard. In this matter, accordingly, the matter is posted for judgment. So judgment is reserved.
Item number 15.
Please, Lordship, in this matter we have issued the notice to the because earlier
Private respondent?
Yes, Lordship. Some counsel was appearing earlier for private respondent, and then it seems that they said they have no more, they have de-engaged some other advocate. So
Or they have engaged?
Yes.
Who is the?
Actually, Mr. A.G. Momen was appearing, and Siddiqui, senior Siddiqui.
No,
advocate,
she's here.
I'm appearing for response.
Oh, you're
1 to 3 years, Your Lordship.
To that effect, there is an order for issuing a notice to the private respondent, Lordship. We have taken
Yes,
a step, but then I don't know whether still we are still awaiting for the service report.
Mr. P.T. Sangwan, the counsel for the petitioner, has submitted that the notice upon the fresh notice issued upon respondent number 4 could not be confirmed as to whether the same has been received or not. It is prayed that some more time may be awaited. Pray allow, this is matter after 2 weeks.
Much obliged, Lordship. Item number 17.
Yes, what is this matter about?
Yes, Lordship. This is regarding the so to say custodial death, Lordship. Custody means the person was that actually not in the custody, but after he was arrested illegally. Thereafter he was released. Then after releasing from the custody, after some time he succumbed to the injury. That's actually the case is about police torture, right? Torture by the police. That's the allegation. The FIR was filed.
See, Mr. Sangwa, you say that he was arrested, then released.
On bail.
Released on bail.
Lordship.
And between the time he was released and the time of his death, how long did it take?
Lordship, I'm satisfied, Lordship. What happened? How the exact what really even happened? Now the case was like this, Lordship. Actually, very fact that the police department, on the other hand, they stated that they arrest, and in their affidavit, they also stated that they don't arrest. But first point, the low point, which I'm trying to argue before this report is the main contention of this. My contention is that Section 54 of CRPC is very clear that any person who is detained or arrested by the police, it's a mandatory as per the law for the medical examination. To the fitness of the that was not done.
Anyway, those you see now, that is a matter of law. It's a matter of procedure that will be looked into. But if you come, you see, before this court per se for against or rather questioning the action of the police, which eventually led to your death.
Lordship.
So that would amount to custodial.
Lordship.
So when
And
he is
then,
no longer in custody, how can you say that?
My second argument will be the conduct of the police. They have even tried to bribe the doctor. It is on record. They have stated they even tried, they have approached even to the doctor, requesting the doctor to issue the backdated medical certificate of the disease.
Backdated.
It is on record. From all this, it is found that the conduct, number one, section 54 of the CRPC, which is the mandatory of law, has not been conducted, and they contradict themselves that they're saying that he was first incident. They said we have taken the disease for his safety. He said that we never arrest. In their affidavit, again they said that he was making some noise, that's why we have arrested, and he was put under some case was registered. And they also stated that the medical examination was not done because doctor was absent. But from the record, there was an order from this honorable court for conducting the inquiry by DSG. The DSG, district session judge, have conduct the inquiry, and from that record it is found that number of times the doctor stated that doctor was very much there. 3 doctors was there, and even doctor says that they even try to request and try to bribe the doctor to issue the back death certificate of the medical examination. All these aspects are there, Lordship. So, Your Lordship, I will just read out first the flag of the case, the events. Then after that, I will just go. Yes, Lordship. Now, let me begin, Lordship.
Yes.
This is the case that petitioner is the wife of the deceased, Lordship. So, wife of the deceased, and deceased name was late Hilary Moman. He was a school teacher in the private school by name Saint Joseph School at Chittimat, East Carville District, Meghalaya. Now, my lord, what happened? That deceased was arrested on 3rd August 2018 by the private respondent, that means the police department, by then the IC of Songsak.
2000 he was arrested?
Yes, on 3rd August 2018.
18.
Yes, 18 by the OC of Songsak. IC, they written IC of Songsak. And after arresting, whole night he was put inside the lockup. On that very night, he was put in the lockup. And according to the petitioner, the wife of the deceased, he was seriously assaulted and he was beaten by the police. And on the next day morning, that is on 4th August, Lordship, 4th August 2018, he was released after seriously assaulted by the police. Since from the day of releasing, from that day he was taken to home. Then from there only, from the police lockup only, he has been complaining with a lot of stomach pain, a lot of back pain, so many other things. And then, however, as per the petitioner, due to financial difficulties, they were not able to take him to the good hospital for a proper examination. They were giving some, just buying some medicine from the pharmacy, because uneducated, they are not just buying, because Chittimat is the place, actually it's a very remote place. It is also very far away from, I think Lordship might have known this, is actually it is between from Reshu to Songsak. It is a very remote place. There is no hospital. From the hospital, it is available only in either in Mendipatra, Reshu, or it should be William Nagar. In Songsak, there is no this one. But the things happen.
So you go from Resu, Mendipathar.
Yes, William Nagar.
William Nagar and Songsak.
William Nagar and
Songsak first. No, first Songsak, then William Nagar.
Yes, Songsak also there is no proper hospital. There is only PSC. Now they said that due to financial difficulties, they were just buying some medicine and trying to treat the patients, the wife. Finally, it seems that he succumbed to injury on 11 August 2018. On that day, yes, Lordship, on 11 August 2018.
Yes.
Yes, on that day itself, my lord, this petitioner, the wife of the deceased,
yes,
she filed the FIR before the Songsak police station, and then case also was registered
on that day, on that mean on 2000 on 11.
Yes, he died on 11/08/2018.
Yes.
And on the same day, my lord, this petitioner, on the same day,
yeah,
she lodged an FIR before Songsak police station, Then the case was also registered under Songsak PS case number 16, Brigade 8 of 2018, under section 304 IPC, Lordship. Then, Lordship, thereafter, it is learned that he also filed some complaint to the human rights. That's one I will come to that. And there was some case was pursuing. Later on, Lordship, he approached this petitioner approached before this honorable court for paying for compensation and also to punish those culprit who was involved in torturing her husband. And the honorable court, on white order dated 16/10/2019, has directed the district session judge William Nagar to conduct an inquiry and to submit an inquiry report before this honorable court. And pursuant, yes, Lordship.
Yes.
In pursuance to the order dated 16/10/2019, Lordship, the district session judge William Nagar has conducted an inquiry into the matter and have submitted the report before this honorable court on 28 February 2020. Lordship.
Yes.
Now they have filed the state respondent also has filed the affidavit is on record from the paragraph 5 in the affidavit. In their affidavit, they have strongly denied, Lordship,
Yes.
that disease was not arrested. They said that he was not arrested, and they says that they have taken only for his safety.
Yes.
Otherwise, Lordship, in the district session report, there is they admitted that he was arrested.
Yeah.
Now, Lordship, in their affidavit, they stated that the disease was not able to take for the medical examination. The reason they have given in the affidavit that could not be done on that in view of the fact that on that day they said that in Songsak, as I mentioned in Songsak PSC, they said there is no doctor. That is the statement, and that is allegation made by the state respondent. And then, due to the absence of the doctor, they were not able to examine conduct the medical examination. Now, as per the inquiry, my lord, I would like to read those inquiry report of the DSG just to clarify the matter. There are so many. There are quite big report on this one. It is around. But I will not read out all this one. But it's around 74 pages. But only some part. I just would like to read out, my lord.
Just a moment. Just a moment.
May I read the paragraph 24, my lord?
The inquiry report is not.
Lordship, I'm sorry, Lordship.
Page?
Page 15, my lord.
15?
Yes.
Yes.
Page 15, para 24. On 18 February 2018, at around 10:30 a.m., I visited Songsak PSC in connection with the instant inquiry case. The distance between Songsak PS and Songsak PSC is about 1.5 kilometers. Inspected the PSC premises, maid and female warden, laboratory, pharmacy, doctors, chambers, etc. And also pursued the relevant register maintained at PSC. One common register is maintained by the Chokidar, who make necessary entry of the patient visiting OPD, and they are referred to doctors. There are 3 doctors presently. Providing their service at PSC. Out of 3, Dr. Jury D. Sira was out of station. Two doctors, namely Dr. Abu Sahih, homeopathic Ayush doctor, and Dr. Anthony Marak were present, and they are maintaining a register of patients attended by them. On the foressure of the register maintained by Dr. Abu Sahih, it appeared that he had attended to 20 patients during OPD hours on 3rd 08/2018. However, it appeared that he did not go to PSC on 4th 8/2018, as register does not reflect any entry in the register of patients, if any, attended by him on 4th 8/2018. Dr. Jury Disira seems to have been attended 16 patients on 4th 08/2018. Dr. Anthony was reportedly on leave after the OPD hours on 3rd 08/2018. My lord, this disease was arrested on 3rd. Now it's that the report, they said that police, they said in the affidavit he was not able to do not conduct the medical examination because doctor was absent. But in this report is very clearly speaking that on 3rd 8/2018, one Dr. Abu Sahih was very much attended. He was attending to the in the for the duty. And very interesting, Your Lordship, thereafter, I will just read out other thing also, that there is no CCTV installed at the PSC premises. 3 separate quarters are provided to the doctors, and separate quarters are also provided to the nurses and other staff. There are 5 beds in male ward and 5 beds in female ward. Some female patients were found to have been admitted in the female ward. Nurses were also available. Now, during the confidential inquiry, I come to learn that after the incident, some policemen approached 3 doctors, Lordship, namely Dr. Jury D. Sira, Dr. Anthony Marak, and Dr. Abu Said separately, requesting them for issuance of some back-dated medical certificate in respect of disease-led Hillary moment. But doctor refused to give the same, saying that they did not attend to any such person, and moreover, late Hillary moment was died by then. Dr. Abu Said does not go to his hometown in Assam. Frequently, he is staying with his wife and minor son at the quarter at PSC premises. Dr. Jury D. Sira has got a house in Williamnagar, and Dr. Anthony Marak in West Karo Hills, and they go to their residence mostly on Saturdays after the OPD hours on rotation basis, with some mutual understanding among them. No duty roster is maintained by the doctor at PSC. However, doctor claimed that one doctor is always available for emergency duty, even during the holiday or night time, even on days when all the doctors are required to attend some training or program in which there might not be any doctor available. Lordship, this is very, very clear. What is the conduct of the police? It is evidence on record. They are guilty of, they even trying to manipulate the things. It is on record. This is the recorded inquiry conducted by the none other than the court, session court, who is the, seems to be a temple of justice, which cannot be, nobody can question the statement or inquiry conducted by DHC. And it is on record. We can question the conduct of the police, the manner in which they are not even sparing, trying to cover up their case, and they trying to approach and get evidence by illegal means. So this is on record, Your Lordship. Now, my argument, Your Lordship, they said that they were not able to examine the disease because doctor were absent. But their statements is substantially, it was completely opposite, and it seems yes,
contradicted by the
doctor, and the doctor were there. Doctor was always there, and worst thing is that they even try to bribe the doctor. They try to manipulate the things by approaching and requesting the doctor to say, give the backdated medical certificate. Now another point, Lordship, that means now, which I like to bring to that section 54 of this one, the CPC. It is very mandatory, Lordship.
(54) of CPC.
54, Lordship.
CPC.
The CRPC, Lordship, not CPC, Lordship. I'm sorry.
The nearest medical officer.
Yes, Lordship, I just read 54. Yes. The examination of arrest person by medical officer. When any person is arrested, he shall be examined by a medical officer in service of central or state government, and in case the medical officer is not available by a registered medical practitioner soon after the arrest is made, provided that where arrested person is a female, the examination of the body shall be made only by or under supervision of female medical officer, and in case female medical officer is not available by a female registered medical practitioner. Lordship, what I'm trying to draw before this of the court is saying that the contention of the state respondent and the private respondent, they're saying that there was a inquest report, medical report. They say that medical report seems to be say that it is died not due to the torture. But now the provision is very clear. My point here is that have it been the disease has been examined by the doctor, it could have been revealed what sickness and what previous sickness that disease has been suffering. Now this is a very clear and it is very doubtful. How can that? That's why the purpose of this act, this section is, after arresting a person, Lordship is very much aware, is very much knowing better than us also, Lordship. The purpose of this act is, the purpose of this section is, after arresting, it is mandatory to examine to know the fitness of the person, to know any background, any sickness, any before arresting anything was there or not. Otherwise, now in this case, it is the fact on record that the person has not been given for conducting the medical examination. That means, how can they say that he has been suffering some other sickness? Have it been the case that he has been examined, medically examined? Then the petitioner, even the disease, will not have a case. But here, it is the fact on record that first instant, after he was detained, after arresting, they have never given for the medical examination, he was never tested, and later on he was released. That's why it is petitioner alleged that he is suffering due to the torture and due to the seriously beaten up by the assault by the police. Now it can be true because even police, they cannot ascertain, they cannot deny, because otherwise why should they try to hide, and why they should not have taken the disease for the medical examination? That's the whole case, madam. Therefore, my argument for this normal court, of course, in this report, my lord, it is stated, of course, that medical report, they say that the disease was not, disease died not due to the torture by the police. They said that the last report, it is stated that page 47 of that 47 of the report, page 47, the conclusion reported.
Yes.
Is it that
page para 43?
Para 43. That is the conclusion, of course.
Yes.
Under the opposite set and fact and circumstances, found that disease has received bruises and injuries in all probability as known to beat up the disease, but not to the extent causing him the death. And as per the Dr. Burman and Dr. Janula Kemarang, injury sustained by the disease were not sufficient to cause death, and NSR Longfellow may not be responsible for death. Now, my lord, that before that, this may I take it to the para 24 of the report. This says, Lordship, this is very much important, Lordship, which I'm trying to argue something on this. Para 25, page 38. Here, may I read, Your Lordship? The post-mortem report of the disease appear to be unsatisfactory. Page 38. Page 38, para 25. The post-mortem report of the disease appear to be unsatisfactory, and though Dr. Himanshu Burman tried to clarify and cure the defect during his evidence, and evidence of Dr. Janula Kemarak was also obtained in respect of said post-mortem report. And from their evidence, it appears that disease could have died due to some underlying disease and not due to injuries sustained by him. But, this is very important, Lordship, but if the Honorable Court deem it proper and necessary, opinion of the third expert could be obtained, preferably neutral doctor from Shillong, to further throw light in respect of the said post-mortem report. So, Your Lordship, there is a saying that the third opinion of the doctor. There's a district session judge have suggested, if the court find, it can be done by the opinion, to take the opinion from the expert, from the third expert doctor. And this was not done.
But have you see, on reading this report, have you approached, have you made a prayer before this court for this, for a third opinion?
Of course,
opinion of a third expert.
Yes, Lordship, we have not, because the petition was filed prior to this inquiry.
Even then, in the course of, you see, once the report is received, if you feel that this is relevant, you could have made a prayer at that point of time, and the court may pass an order.
Lordship. Now, yes, Lordship, but here, Lordship, I'm not so much stressing on it, but I just read it, but it is...
But that is relevant, you see, because post-mortem report will reveal...
Yes, Lordship.
Even if there is a, even if there are some injuries, antemortem, it will be revealed in the post-mortem report.
Yes, Lordship. Now, I just like to... I have filed my written argument, Lordship. In my written argument, I have put some... in my written argument, I have put some annexures, Lordship. It seems that during the pendency of this case, it was found that there was some magistrate inquiry also has been done. But, Your Lordship, it was, may I just take, may I take it to the, my written argument. It is at last page 32. The last part. Page 32. There's so many other things that they have spoken, but it may take time, but the observation made by this one. It was conducted by A.C. Marak MCS, Additional Deputy Commissioner. Yeah, read your last para. It appeared that there has been a miscarriage of justice as the infringement of fundamental right was noticed due to the police personnel misconduct, which definitely invoked state liability. As the Article 21 of the Constitution has been violated, which provide for protection of life and personal liberty. The family of the deceased late Hillary Moman look totally disposed of all life supporter and life in utter despondency. They deserve to receive compensation from the state government at the earliest. This is what observation made by the additional.
This is a ministerial report.
Lordship.
Where it starts from?
It start from it starts from page. Page.
It is not a part. It is not a part. He has to bring this by way of an affidavit.
It's not.
Oh.
That is not
part of the
record, Your Lordship. This has come to us as a surprise. In fact, in the written argument, he has enclosed this. It is not a part of the record.
Not
Let
a
him
part
bring
of
it.
the record.
Let him bring it on record by filing an
It should be
affidavit.
brought, Mr.
Now they.
How can he argue on this?
Yes, you cannot. I thought it was part of the record.
No, it is not a part of the record.
Because if he brings this, Your Lordship, as my friend said, he has to file whether this, Your Lordship, is whether this will override the judicial inquiry or not. That has to be seen.
Whatever the case may be, see, it has to be brought on record, and then it can be compared or.
Because the order of the report inquiry submitted by the Lanet District and such has been done in compliance with the order passed by this court.
But there is no. You see, we'll have to look at the aspect of the matter as to whether the inquiry report filed by the district judge will override the report filed by the magistrate.
This is Lordship, that has to be seen, Your Lordship.
Lordship.
Then let me file, Your Lordship, so that.
That I may be permitted to file an additional affidavit, and otherwise I have someone to argue, Lordship. But then,
unless he files an affidavit and
Yeah,
places
I
on
think
record and makes it a part of the record, he cannot rely on this. This is.
Lordship,
a foreign document that has been just annexed to a written argument.
Mr. Sangma.
But sometimes, Lordship, earlier occasion, in the written argument, some argument.
In written argument, what you can do is you can refer to some authorities, or you see whatever is there in public domain that you can do. But this is specific.
So, Lordship, necessarily order may be passed to allow me to just file on that only on the document to bring on record. Otherwise, it is on there even just because I have not filed it through affidavit, only enclosed in the written argument.
It will be there, of course.
It is there with them also. However,
No, Your Lordship. We file the police filed the affidavit, Your Lordship.
And how did you get this copy?
This one after filing of the repetition only they brought up, Lordship.
No.
My Lord, what?
No, it was never brought, Your Lordship, by the either by the state or by the private respondent. What happened, Your Lordship? Initially, then since it involved a disputed question of facts, Your Lordship, that's why this court was pleased to direct a judicial inquiry, Your Lordship. Even I did not oppose at the motion stage. Also, I did not oppose, Lord. Then we filed the affidavit. That much only. All this were never. How he is privy to this? Then the source has to be disclosed, Your Lordship. By the
Yes. How did you
petitioner.
get this? Was a copy given to you?
Yes, given to the petitioner.
You means you are the petitioner.
Yes, I was given by yes.
My Lord,
this
what
notice was given to the petitioner.
My Lord, what my friend has done here is he has approached multiple forums. He has also filed a complaint before the Human Rights Commission, which I can understand after going through this affidavit, through his in his written argument. So he has approached multiple forums, and this I believe he has obtained this copy after a copy of this was sent to the Human Rights Commission.
Your Lordship, I will just get a
sent to the Human Rights Commission.
Lordship, in fact, this is confidential. If Lordship will,
confidential report.
If Lordship will have his written argument, Your Lordship. If Lordship is pleased to come at page 33 of that written argument filed by the petitioner.
Yes.
Lordship has got it. Page 33, Your Lordship, of the written argument of the petitioner.
Yes.
Lordship will see this is the letter of the district magistrate addressed to the Secretary Meghalaya Human Rights Commission. Then kindly come next page, Your Lordship, at page 34. This is the letter from the additional deputy commissioner to the deputy commissioner William Nagara. So how he has got this copy, Your Lordship? It's very
given
strange.
to the petitioner that this is present petitioner. So they produce, maybe they have given all this copy to that.
Then you have to file. If you file an additional affidavit to bring this on record, you also have to file the receipt along with it.
Yes.
You have to state very clearly how you have got it. And the
How
copy
is
of
privy to this?
Yes, copy of the receipt
Lordship.
If
They said that they, for some post office mean the postmaster they may not give.
Cannot. We are in the court of law.
It is not mentioned anywhere whether if a copy is given to the petitioner. If,
No,
if a
it's
copy
not
is given to a
but
third party,
they might have given it. There's no problem because
they might
just give, this human right or some other person might have supplied to them. But even it's not necessary to show that copy. Sometimes officer they don't show the copy to so and so, but it's not required. But in this one they have obtained. It is not illegally that she's just a lady. She cannot just go to some other office and cannot be like stealing or something. It is not at possible. But
that may not be
people
so.
have they brought.
That may not be so, Mr.
Yes.
Sangma,
And
but
then
the point is everything has to be done
Lordship.
in accordance with procedure.
Yes, Lordship.
There is a procedure of how you introduce documents in the court.
Lordship.
Could be a red code,
Otherwise,
but the principle will be the same.
we will not. I will not insist or will not even file it. I will just go by that the police the DSC report and then will not touch into this.
But this has become
If they are opposite.
this has become part of the proceedings.
Lordship. Then Lordship is just I will just.
And what about this? You see, as has been submitted by Mr. Gautam, that you have also approached the human rights.
Yes.
So
It seems to
can you approach two forum at the same time?
That we'll see, Lordship, because that they have approached. Other it seems to be, but this copy
No,
I just
then
got is that's
who
right.
see? Can the Human Rights Commission take a sumoto notice of all these incident and start the proceeding? There must be some complaint or some petition file.
Lordship.
Who has done that? Whether you or some other parties? If you have done it, then you have to explain to the court why you have approached multiple forums. And what is what would be your stand?
We'll get an instruction, Lordship. This part.
Why not let all these come by way of an affidavit, my lord? Let him file an affidavit to that effect.
But prima facie, you have a case. If that is so, this court will come heavily on whoever is involved. But you have to do it properly.
Lordship.
In course of hearing, Mr. P.T. Sangwa, learned counsel for the petitioner, has in his argument sought to rely on the inquiry report, initial inquiry report conducted by the Additional Deputy Commissioner, East Garo Hills District, and which report is dated 28/8/2019. However, on the petitioner's reliance on the contents of the said report, the learned AAG, Mr. N.G. Shulai, you are appearing for, and Mr. Guru, you are appearing for whom?
I'm appearing for respondent number 7.
Who is respondent, sir?
Newly implemented
They have filed an application.
police
to
officer, Your Lordship. That police officer what pick
All the allegations are made against me.
That no cloud.
No, Your Lordship, yes.
And the Kunum Toko? Appearing for the state respondent, as well as Mr. K.C. Gautam, learned counsel for the respondent number 7, have raised an objection to this, submitting that the respondents are taken by surprise in this regard, since the contents of the said inquiry report is not part of the records herein. At this juncture, the learned counsel for the petitioner has sought for time to seek instruction in this regard. Seek instruction in this regard. And if so advised, to approach this court by way of, and if so advised, to file an additional affidavit bringing the said report and other relevant materials not brought earlier before this court.
May I submit, Your Lordship, and also the proceeding before the
Yes, that
Human Rights Commission, Your Lordship.
yes, I'll do that. Not brought before this court, comma, to the notice of this court. Another aspect of the matter raised by the respondent herein is that the petitioner may have, in course of these proceedings, also approach the Meghalaya Human Rights Commission on the same subject matter. Here too, the counsel for petitioner has sought for time to seek instruction. On consideration of the submission made, the court, in the interest of justice, would allow the petitioner to take necessary steps in this regard. As prayed for, this is matter after
3 weeks, Lordship.
3 weeks.
Lordship. Apply, Lordship.
Apply.
Lordship.